What's up, design family, and welcome back to another episode of Fittdesign TV. So glad to have you back on the channel. On today's episode, we'll be looking at the importance of protecting intellectual property within fashion design. This is an often overlooked area of fashion because it's not as exciting as the creative part. But I cannot overstate the importance of creating and securing your designs. We'll run through 4 key methods that you can apply. We'll run through sort of the costs of them and the levels of intensity and what they cover, as well as how to potentially get these registered. You have 4 key methods. Number 1 will be your copyright. Number 2 will be your trademark. 3 will be your registered design, typically denoted by an R. And then lastly, you have your utility patent. We'll run through each of these categories and what they entail. If you've ever been confused or been interested in protecting intellectual property and what that entails, watch this video. You're going to learn everything you need to know. Hey guys, and welcome to Fittdesign TV. So glad to have you here. On this channel, we discuss all things sports fashion, graphic design, manufacturing, and technology. We'll discuss key topics, answer pressing questions, and provide actionable steps on starting your own product line. If you're interested in any of the above topics, stick around. You're in for a good one. The first tools at your fingertips when it comes to protecting your intellectual property is by registering a trademark. Chances are you've seen the TM symbol pretty much everywhere on your favorite brands. TM stands for trademark, and this essentially protects your logo. It protects your logo from others using it without your explicit permission at the same time. Usually, when no claim of color is made in a registered trademark logo, this will protect the logo from use across all color schemes, so that's not something you have to worry about. Usually, you would register your logo in black and white, and this will protect it across all color varieties. At the same time, if you know which countries that you're looking to expand in, it's important to register the trademark in every single country you plan to trade in. Different countries have different trademark laws, so it is important to look into the specific countries that you'll be operating in. You can go for a more collective trademark organization like the World Intellectual Property, or WIPO, and this will protect your logo from use in over 90 member countries. So you're sort of hitting 90 birds with one stone when it comes to registering with WIPO. At the same time, you need to look at the trademark protection length. This differs from entity to entity and depending from country to country, but generally trademark protection is for 10 years. If you need a trademark protection for longer than 10 years, you may want to take that into account when you're creating your expansion plan. Also, when it comes to cost, trademarking can be a decently costly process, so it is important to look into what your options are, and ultimately, if you have the option to trademark, you should. The last thing you'd like to do is to launch a brand, put in all this time and effort, and neglect to trademark. Some of the biggest brands out there have actually pretty interesting stories where they launched a brand and a couple of years later, someone registers the trademark behind their backs and sells it directly to them. So make sure you don't get caught in this trap because it could potentially cost you a lot of money. Spend a little bit of money now and save it in the long run. You can go after someone with legal action if they're using your logo in similar products or services without your permission. And at the same time, if the use of this logo is so similar, it doesn't have to be identical, and it's the same industry, that it ends up either devaluing your brand, detracting your potential customers so it confuses your customers, or it represents your brand in a way that isn't the best. So it ends up actually defrauding your brand. Should you pursue legal action? Obviously, this is a last case scenario. Typically, it's good to solicit and to issue a cease and desist. We can go into more detailed videos regarding legal action, but know that you can go after someone if they infringe on your trademark. The second type of intellectual property protection is copywriting. This is one of the most common types, and it's implicitly implied when you create an original piece of work. Copywriting is denoted with the symbol C, and this protects original pieces of work of authorship that include things like photography, art, video, design, and all the drafts and iterations associated with that piece. It's important to understand that copywriting does not need to be registered. It's implicitly implied when you create a piece, and if you've created the work, you will automatically receive copyright protection. One thing to denote is when you create an original piece, it's good to register it with the C symbol and the date. This can tell others that this is a copyrighted piece, and that if they were to copy it without your permission or to borrow extremely heavily from it in ways that are quite discernible, that they would be infringing on your copyright. It's also important to keep a record of the research and development of this piece, whether it's the iterations, drafts, mood boards, inspirations. The more data and the more actual information you have that support the original creation of this original piece of content, the better your chances are of protecting and solidifying your copyright. So do keep that in mind. The length of a copyright traditionally varies, but it's around 50 to 70 years, and that's pretty much when you create a piece, you have the copyright for that long. Because copywriting is instantly available and it costs nothing, it's the most common way to protect your intellectual property. And if someone is copying you or distributing or modifying an original piece of work, you can pursue legal action against them. At the same time, if someone takes work and modifies it, but your original creativity is quite discernible and quite prevalent, this can also be a grounds for you to go after and protect your copyright. What does it cost? It costs nothing and it's automatically registered. So do take advantage of that. Know how to protect your copyright and know how to actually present your copyright in a way that is owned by you. The more work you can do upfront to make sure that this piece of content A is rightfully yours, so you can't copyright something where you're ripping it off someone else. So do bear in mind that copywriting should be of original work, and at the same time, when you do have a copyright infringement case, make sure that you have the necessary resources to back up your copyright claim. And number 3, when it comes to protecting intellectual property, is the registered design, typically denoted by the symbol R, and a registered design, or otherwise referred to as a design patent, protects the visual appearance of a functional object. So what does a registered design protect? Well, it protects the visual design of the objects themselves. So what you see, it protects things like the shape, the color composition, the arrangement of shapes, so on and so forth. When it comes to registered designs, do bear in mind that they are only valid in the countries where the trademark is registered. So if you plan on trading a specific product in a different country, make sure to register your design patent beforehand. When it comes to the length in which most design patents can be registered, it's typically around 14 years. However, this is easily extendable. So when to pursue legal action? When it comes to someone infringing on your registered design, you can pursue legal action when someone is applying your registered design to their own products or services without your explicit permission. Last but not least, we have our utility patent protection. This method differs from the other 3 methods that we spoke about in that it relates directly towards protecting the functionality of an invention. When it comes to the fashion world, utility patents are typically applied to fabrics or when a design has a high-tech aspect. When it comes to a utility patent, this will stop others from making, using, or selling products that employ this invention on their own without your explicit permission. When a patent is granted, the invention becomes the sole property of the owner or the inventor. At the same time, this patent can be bought, sold, hired, or rented out just like any other asset. So what you see is these large utility companies that buy up all of these patents and then they sell them or they rent them. This can be unethical at times and can actually stunt growth, but if used in the right way, can help protect your hard work and your efforts, and can actually push the industry forward by preventing others from copying your ideas. Utility patents, like the other methods, are only valid, except copywriting, are only valid in the countries in which the trademark is registered. So if you plan on trading in a specific country, make sure to register your utility patent first. You won't be able to register a utility patent after the fact. So once a product is launched, you can't go and then register the utility patent later, because there is no proof that you are the original inventor of this patent in this market. So do bear that in mind. It can be a little bit of a loophole. At the same time, a utility patent, just like a trademark or a registered design, has a span of 14 years. And this is actually extendable. So you may want to plan ahead to make sure that you extend your utility patent when the time comes. When it comes to protecting your utility patent, you can pursue legal action when someone is using your patent without your explicit permission, or someone has made, copied, or imported products that have a patent or a functionality that's extremely similar to yours and something that can be proven in a court of law or can be proven beyond a reasonable doubt. So by having a clear utility patent, you have a great case against someone who's genuinely copying from you. This is the most expensive way of intellectual property protection, but it can save you a lot of money down the line. If you have a great invention, chances are it's quite valuable to protect that beforehand so that in the future, you're able to safeguard the interests of your business and to potentially even rent it or hire it out, depending on how universally viable that patent is. I hope you guys have a clear idea by now of the importance of protecting intellectual property. Yes, it does cost some money up front, but it does save you a lot of heartache down the line. Don't be the brand that neglected to safeguard their vision and their original ideas because they didn't want to spend some money up front. There are many different ways to register copyrights or trademarks or register designs or patents, and you'll need to look at the specific ways that your country treats each of these methods. It's not complicated. We've personally done it before, and from experience I can tell you that going for a unified organization like WIPO can be a quick way to register a trademark across a wide variety of countries. If you guys enjoyed this more technical video, I know that when I first started off in the industry, I always wondered, how do I protect my work? What's the difference between a trademark and a copyright? So hopefully this video has helped clarify these terms. Thank you guys so much for tuning in to Fittdesign TV. If you guys haven't subscribed, please consider doing so. We put out great content like this on a week-to-week basis on things that range from technical videos and fashion to more business-oriented videos. If you guys want to see more content, make sure to come back, check us out every week. Until next episode, guys, stay awesome.